Hi, I'm Dwayne Duggan, Remax Boulder Video Podcast. Today we have Gina Weinberger. She's a real estate attorney and an estate planning attorney associated with Remax Boulder. It's such a pleasure to have somebody with as much wisdom as you at our office on kind of our beck and call. So
thanks for having me here.
And thank you for being here. We really appreciate it. So one of the things that as a real estate agent that oftentimes I'll get a call and the seller has passed away. And so today's topic with Gina is to talk about how do you sell a home on behalf of an estate. So when I get a call like that, Gina, and I get the word that the seller has passed away, what's the first step that, as a realtor, that I should start checking out to get the property ready for sale?
Right. Well, the first thing you're going to want to do is find out how the decedent actually held title.
Okay.
And just looking at the public records may be insufficient. What you're really going to want to do is pull out the last vesting deed and take a look at that deed and see how they actually took title. Because you can have the same person or same people take title in a couple different ways that really affects how that property transfers at their death.
Okay. And so what are some of the examples of how title is typically held? What might I find when I look that information up?
Right. So when we talk about co-ownership or more than one person owning real estate, in Colorado there are two ways to own property with another individual or with a group of people. So that's as joint tenants or as a tenancy in common. And when you own property as a joint tenant, that means that when one owner dies, their interest automatically passes to the other owner or owners. So you don't have to do anything, it just passes by operation of law. Now, if you have a tenancy in common and one owner dies, that interest does not pass automatically to the surviving owners. It passes to their estate, which will very likely have to go through probate to determine where that goes and who has authority to sell it.
Okay.
Right. So
As far as joint tenancy, like when the question comes up in the typical real estate transaction, a married couple buying a home, they almost always pick joint tenancy. Can you think of an example off the top of your head where somebody might pick tenants in common rather than joint tenancy?
Right. So a tenancy in common is very common when you're going into a business transaction.
Okay.
And you want to buy property with another individual, but if you die, you want your family or your own spouse to benefit from that interest. You don't want the surviving owner to automatically assume that ownership interest. So a lot of times also in Boulder, especially when young folks are trying to buy and they can't afford to do so on their own, they might have one or two parents get involved.
Okay.
And that's another good reason to choose a tenancy in common, because then those interests are passing, more in the direction of your beneficiaries and less just to the other owners.
So to me that kind of sounds like if you are going to partner with somebody, whether it's with your family members or just business partners, it's a good idea to visit with an attorney to make sure that you're holding title right. And then
Sure.
I don't know if now's the time to just mention, like, do sometimes people do the LLCs or different forms of holding the title as opposed to just joint tenants and tenants in common?
Right, absolutely. So a lot of times, especially if you're buying as a business, or if you are buying and putting it into a trust, you might see that the actual owner is an LLC or a trust, and then you're going to want to turn to those operating documents or that trust agreement to see who controls the property when the grantor in that case died, or who has authority to sell the property on behalf of the company or the estate. So that's really going to be a case-by-case basis. You're going to have to go beyond just the vesting deed to find out where that goes next.
Okay, and then you mentioned trust. It seems like a few years back, estate planning attorneys, because of the estate laws at the time, were really pushing to have properties owned by trusts. So you could run into the trust being the owner, and then you have to figure out who's the signer and that type of thing. Is that correct?
That's correct, yeah.
And not to get off on a big of a tangent, but is a trust a real typical thing that estate planning attorneys are doing for the average American right now, or?
They're very common. Irrevocable trusts especially are very common. Whether or not that's appropriate would just depend on your specific situation.
Okay.
But they are common, so you'll see that a lot of times when you're transferring property, it'll be done in a revocable trust.
Okay. So again, as a realtor looking at the phone call that comes in to list a place, you could find a whole variety of how titles held, whether it's joint tenants, tenants in common, maybe an LLC owned by a a trust.
Mhm.
So is that pretty much sum up everything that you would run across, you think? Or
Right, so that'll sum up the ways you might own the property, and then in terms of the real estate transaction, the tricky part's going to be if a property has to go through probate.
okay,
Making sure that you have started that process before you get too far down or too close to closing, because some of those steps have to be taken to satisfy some title requirements.
okay. And then if there's two owners on a deed,
Mhm.
and then but one of the married couple has passed away,
Mhm.
any special considerations that we need to check out there?
So you mean just only one of the owners died?
Right, just one.
So that's really where you want to look. Did they take as joint tenants? If they
Okay.
took as joint tenants, your job's going to be pretty easy in terms of selling that real estate, because now the surviving owner has sole ownership, and they'll have sole authority to sell that piece of real estate. But if it turns out that they actually owned as tenants in common, then you're going to have to go through probate. You're going to have to at least open probate and have someone, and oftentimes this will be the surviving spouse, named as the personal representative before you get to the closing table. And if that's the case, then sometimes this surprises people. They think that they own as joint tenants,
Right.
and it turns out that they actually own as tenants in common. And there's a scramble to make sure that you can get probate opened. In reality, make a phone call to an attorney right away. They can usually keep you on your closing schedule. It takes about a week to 2 weeks to get the personal representative appointed. And that's really what you need to do before you get to the closing table, to make sure, if it was held as a tenant in common, that someone has authority to sell on behalf of the estate.
Okay, and you've mentioned probate a couple times, and open probate. I'm trying to visualize probate. In other words, it's open it like behind a door type thing. What's an involved open probate? Who does that? Who do you call, and how does that get started?
So you call an estate planner or probate attorney.
Okay,
They file documents with the court. If there's a will involved, those documents have to be uncovered. If there's no will, you'd still have to go through probate. So either way, you have to you petition to open probate, and then you petition to have a certain person appointed as the personal representative.
okay,
So this is all just filing documents, and assuming there's no contest, things run pretty smoothly. And then you'll get issued what are called letters, testamentary, and the title company that's involved in the transaction is going to want a certified copy of those.
okay. I think a perfect example of a big issue, Prince dying without a will.
Right.
I mean, that's a perfect
Oh,
example
gosh.
of why it's good to have a will or see an attorney will in advance of as soon as you own a home, to make sure that you're holding title right.
Absolutely.
Because the fear as a realtor in terms of time is that you hear the word probate, that it takes a bunch of time, like in the case of a prince, that they could be fighting over that for years.
Sure.
But the average American that owns a house and a car and a couple other things, probate to open up and get it all ready to go is, based on what you said, a couple-week process or so typically, or?
Well, probate overall will take between 6 and 9 months. But when
Okay.
you're talking about a real estate transaction, what you really want to make sure is that probate's opened and
Okay.
a personal representative is appointed who has authority to sell real estate. So you can sell real estate during probate. The buyer can walk away. Those funds go back into the estate's name, and then you'll have to carry on with the probate process.
Okay,
So that takes longer. But for purposes of a real estate transaction and keeping that sort of on track, it's really not that daunting. You just want to make sure you act quickly and you get a personal representative appointed with authority to sell the real estate on behalf of the estate.
okay. Anything else that you had on your mind that you'd like to share?
Well, I could talk about this all day, but
Okay.
I think we covered a lot.
Okay, well, why don't you go ahead and give your contact information? Obviously, the whole estate planning process and probate is all complicated, so why don't you give our viewers how to get a hold of you if they'd like to discuss it further for their own specific case.
Well, great. So again, Gina Weinberger, Weinberger Law, LLC. You can email me at gina@ginaweinbergerlaw.com or call me at 720-588-9830.
Gina, thank you very much for being here. I know it's a tough subject for a lot of people to talk about, but again, the more people can plan in advance, it makes it so much easier for those left behind. So thanks for being here today.
Thank
Appreciate
you.
it. Dwayne Duggan, Remax Boulder Video Podcast, signing off.